Good morning. My name is Tom Cosgrove. I'm the Senior Vice President for Public Affairs and Knowledge Exchange here at Farm Credit East, and I'm pleased to welcome you to the first of our 2017-18 Winter Webinar Series, and today's webinar on I-9 compliance and immigration enforcement. And before I introduce our presenter, I just want to mention our internal sponsor, the financial services team here at Farm Credit East. Our staff provide a number of services, including those listed, as well as tax preparation and payroll services to help with your business success. So please contact us if you want to learn more about those. So in terms of today's topic, as we talk to Farm Credit East members across our territory, access to labor and a stable legal supply of workers is always one of the top concerns that we hear, and one of the main challenges producers are facing. And as we know, many farm businesses employ foreign-born workers, and certainly ag labor has been a hot topic this year in Congress and other places. The House Judiciary Committee has passed a new Agricultural Guest Worker Act under the leadership of House Judiciary Chairman Bob Goodlatte, establishing a new H-2C visa program. And while certainly the prospects for that legislation are uncertain, we're not going to focus on what the proposals are going forward. We're really going to focus on what are the existing rules of the road, because there's really plenty to unpack with the existing regulations. And today we want to focus on an important piece of the hiring process, the I-9 form and the associated compliance and enforcement that goes with that. And so to review this with us today, we're very pleased to be joined by Leonard, or L.J. D'Arrigo, from the law firm of Whiteman Osterman Hanna in Albany, New York. LJ specializes in the area of immigration law and is an expert in a wide range of issues in the practice of immigration law, especially as it relates to agriculture, including the handling of H-2A and H-2B visa issues. He's the immediate past chair of the upstate New York chapter of the Immigration Lawyers Association. He holds an undergraduate degree from the University of Albany and his Juris Doctor from Albany Law School. As Heather mentioned, following LJ's presentation, we'll take questions from the audience. As she said, to ask a question in the GoToWebinar control panel, there's a red arrow up there that you can expand and type in your question. Also on that control panel is a PDF of today's presentation if you want to take a look at that or for reference afterwards. Just going to show a quick legal disclaimer in terms of today's presentation. And with that, I'm going to turn it over to LJ for the presentation. LJ, if you want to share your screen and take yourself off mute, we'll get started.
Okay. So I want to first thank you all for taking time out of your day to participate in today's program. I'd also like to thank Farm Credit East for organizing this event. In this era of ever-increasing enforcement, it's really critical to have an understanding of the I-9 hiring process, as well as compliance requirements. ICE does take a no-tolerance approach to I-9 completion, so there's the potential for significant employer sanctions and penalties for seemingly minor errors and non-compliance. So you may ask, why do we need to spend an hour on a two-page form? The fact is that the I-9 Employer Handbook that goes along with the actual form is 69 pages long, so this pretty much answers that question. The I-9 form is riddled with traps and ambiguity, and given ICE's policy of strict compliance, you really need to know how to avoid these traps. So today, I want to cover the I-9 hiring process and some of the pitfalls, I-9 completion and record keeping, as well as the I-9 audit process. We do have a lot of information to cover in this session, so it'll be a more general overview. If you have specific questions that are unanswered at the end of the program, you can contact Farm Credit and they can field any additional questions to me, or you can contact me directly as well. So we'll get right into it. So I think it's important to understand the current situation in terms of the current enforcement priority and mentality. So there's an enforcement emphasis that's running through all aspects of immigration, especially in our current administration. So the old approach has really been to conduct I-9 raids and roundups, focusing on those industries that traditionally have been associated with turning a blind eye to immigration, and that would be hospitality, agriculture, construction, and manufacturing. So these are still really focus areas, but we're seeing an expansion now in worksite enforcement across all industries, all states, and all company sizes. So the current focus is employer liability, and the administration believes that by going after the employers who hire these foreign workers, that's where we need to focus on to stop the influx of illegal immigration. So we see enforcement initiatives expanding rapidly. There's worksite enforcement units that are embedded in various service centers of immigration. We see new ICE initiatives. They're releasing notices of inspection to a broad range of employers and industries. And there's now a new centralized unit to conduct I-9 inspections. And this function is very well funded. So there's money available to fund the enforcement machine. So the first time that we've ever saw a crackdown on illegal immigration or any laws that affect employers in hiring unlawful immigrants would be the Immigration Reform and Control Act of 1986. So this was one of the first amnesty programs that we saw for immigration. And so what the situation was at that time is we had a really intense immigration problem. So we had thousands and thousands of workers here, if not millions, that were working on farms and in other industries undocumented. So it wasn't feasible to just round up 6 million people and send them home. It would completely shut down the economy. So the government recognized at that time that we need to do something. And it's interesting because we see parallels today with this problem as well. So the government agreed to provide amnesty to certain illegal aliens that were long-term residents of the U.S. and who had an employer standing behind them. However, the trade-off was to limit future illegal immigration, and they did this by instituting the I-9 form and the I-9 requirements, as well as developing sanctions that apply to employers who knowingly hired illegal workers. So you see, we had these two competing mandates. An employer was required to verify all new hires to make sure that they had appropriate paperwork in place, but at the same time, they weren't allowed to discriminate against applicants during the process. And that's always been a difficult balancing act. And we're going to talk about a little bit more about that in a moment. So some of the sanctions that apply for employers that hire unlawful workers, there's civil and criminal penalties. If you haven't already, I would certainly recommend going on to the uscis.gov website, and you'll see on there under the I-9 section, there's a handbook for employers. This is really your Bible in terms of I-9 completion and hiring, and I consult with it every day myself. There's great information in there. If you have any questions about filling out your I-9 form, I recommend reviewing that handbook. But it talks about civil penalties. So there are civil penalties for unlawful employment, and that would include hiring and continuing to employ unauthorized aliens. So these fines range between $375 per violation to $16,000. Failing to comply with I-9 requirements, that would include forgetting to complete an I-9 form or filling it out incorrectly. So you could face fines between $110 to $1,100. There are also criminal penalties. So if you're found to have a pattern or practice of hiring unlawful workers or I-9 violations, you could face criminal penalties up to $3,000 per employee or 6 months in imprisonment. Document fraud, there's civil and criminal penalties, unlawful discrimination. So, it's important to keep that in mind, especially given the increase we're seeing in notices of inspection issued in I-9 audits. Some of the big companies we've seen recently, IBM had a $44,000 fine for having a citizenship preference in ads, which is frowned upon. You can't have a U.S. citizen-only hiring process because that could lead to allegations of discrimination. Walmart had an $11 million fine assessed against it for violations. So they don't always go after the large companies, and we're seeing more of a focus now on smaller businesses because the reality is they know where to look for workers that have historically been out of status, and so there's sort of a target on some employer backs, and we see this in the seasonal industries as well. So non-discrimination requirements. The basic rule is you're not allowed to discriminate against applicants in the hiring process, even though you have the responsibility of proving that they're legally able to work for you. So the agency that's charged with enforcing this is part of the Department of Justice. It's called the Office of Special Counsel for Immigration-Related Unfair Employment Practices. So this organization or agency enforces the prohibitions on citizenship and nationality discrimination. They set policies on discrimination, preventing employers from asking seemingly minor questions about somebody's status. One of the worst things that you can do is over-document. And this doesn't make a whole lot of sense in reality, because when you're filling out an I-9 form, you have all sorts of options to choose from in selecting the appropriate documents to prove identity and work authorization. But then you can also get in trouble for collecting too many documents. Doesn't make a whole lot of sense, but this is called over-documentation, and it does give rise to an allegation of discrimination. So can I ask to see an employee's green card if they say they have one? The answer is no. You may never ask an applicant or employee to see a specific document in connection with the I-9 process. You must accept all documents if they appear to reasonably relate to the person and appear to be valid. The exception to this would be if a document presented doesn't appear to be valid, it looks fake, or it's expired. So if someone gives you a green card written in crayon, you're on notice that there's probably something wrong with that person's status. There's also a very useful guidance document called the Form M396. That's a guide to selected U.S. travel and identity documents, and that's available on the USCIS website as well. And that has actual photos, color photos of various documents, what they look like, so that you can, if someone shows you a green card, you can actually see if it really looks like a green card is supposed to look. All right, so we're going to move on a little bit to the hiring process and where some of the problems arise. So U.S. workers are protected from employment discrimination based on national origin and citizenship, as well as several other Title VII grounds. As part of this, employers need to determine an applicant's immigration status during the hiring process without potential liability for discrimination. So at the end of the day, the motto that I always go by is look at the facts, not at the faces. You'd be very surprised a person's immigration status based on how they look. And you can't profile. So if someone looks like they may be from Mexico or South America, on many occasions they may be a U.S. citizen. If someone looks, doesn't look like they're from another country, well, it doesn't mean that they're not. They could be from Canada or Europe. You just don't know. You cannot judge a person's immigration status by how they look. Surprisingly, some of the things that are illegal for you to ask, which comes to a shock to most people because it kind of doesn't make so much sense. It would be so much easier if you were to ask some very simple biographic questions in the interview process. You cannot ask somebody, are you a U.S. citizen? You cannot ask them what country they're from. You cannot ask, do you have a green card? You can't ask them if they have a Social Security card. You can't say, if you're not a U.S. citizen, what visa do you hold? Those are all illegal questions in the employment hiring process. And if you could ask those, it would be a very simple matter to determine whether someone needs a visa or whether you're going to get in trouble if you hire them. But again, we have this mandate where you have to verify employment, but you can't discriminate in the process. So the Office of Special Counsel has arrived at an official question that you can ask an applicant without running afoul of the discrimination rules. So what the official version of the question is a little bit confusing, and nobody really would understand it if you asked that in an interview. So what they say is you should ask, do you have unrestricted work authorization for the U.S., which is, are you a U.S. citizen or national, a U.S. permanent resident, an asylee, a refugee, or a temporary resident of the U.S.? Well, they're going to look at you like you have three heads if you ask this question. So a clearer version, which has been sanctioned by the Office of Special Counsel, would be, do you currently have unrestricted work authorization for the U.S., or would you require sponsorship for a working visa? So this very simple question is going to let you know if they have unrestricted work authorization and would not need sponsorship. So this would mean maybe they're a U.S. citizen or they have a green card. They may say, I have work authorization now, but would need sponsorship in the future. So maybe they have some sort of temporary work permit that allows them to work for you, but it's going to expire at some point. And lastly, I would require sponsorship for a working visa. So this lets you know they're probably from another country. They need you to sponsor them for a visa before they're able to start working for you. So now I want to talk about the actual I-9 form itself, which we refer to affectionately as the form from hell, because that's what it is. So the current version of the I-9 form is the July 17th, 2017 version. So you should all be using that version of the form for completing I-9s. It's really the same information as before, but it has some improved graphics and organization. The important thing to note that there is no single document that someone can show you that proves identity and work authorization. It's usually going to be a combination of documents because some visas include work authorization, others do not. Some foreign employees need employment authorization documents, which are EADs, some do not. Asylee and refugees, they may have employment authorization without an actual visa or EAD card. The key rules for I-9 completion, which are probably where I see the most violations, are in the timing. There's a very specific timeline by which you need to prepare the I-9 form and have it signed. So you have to complete the I-9 process within 3 days of hire. So the employee completes part 1 on the first day of employment. So they'll come in, the first thing they're going to do is meet with you to fill out that part 1 of the I-9 form. The employer will complete part 2 by the end of the day 3 of employment. So you have basically 3 days to finish up that I-9 form and sign it. And everything needs to be signed, dated to correspond with this timeline. For part 2, and I'll show you the form in a minute. For part 2, employee chooses and presents to the employer documents from the authorized list. So that's a very important aspect of it because, and we'll go into this in more detail in a minute, but again, you are not allowed to tell an employee what document to show you. Your job is to give them a list of the available documents. There's list A, B, or C, and they are supposed to select the documents. Otherwise, you're going to be accused of employment discrimination. So for this first page of the I-9 form, the first thing is it must be completely filled out. You don't have to necessarily fill out the employee's portion, but what you do need to do is sit with them and then give them the instructions for completing the I-9 form, and then you can help them out and translate things for them, but you do need to have them fill that out in your presence. The Social Security number box is optional unless you're using the E-Verify program, which is basically an optional online system for you to verify somebody's employment authorization. The employee attestation box is critical. You need to have them sign it within that box and date it with today's date that they fill it out, and all of the dates have to fall within that 3-day required period. What I see when I review I-9s or do internal audits for companies, I see that sometimes there's dates missing. That's a big deal because when immigration comes in and wants to inspect your I-9s, that's the first thing they're going to be looking for, to make sure that it was dated, that it was the proper date on it, and that things were signed. And that's where you can get into trouble in terms of fines when things aren't signed or dated correctly. So section 1 of the I-9 form, again, significantly improved graphics over the previous form. There's actually drop-down menus to select different things. There's expanded room for all the required fields, and there's really no more controversy where the employer is to sign. What we were seeing in years past is that they had a line for the employee to sign, and immigration was assessing fines against employers if they signed under the line instead of on the line, which is absolutely ridiculous, but they got away with it. So now, to kind of avoid the confusion, there's a box. So you just fill within that box, and then they have also clarified that that wouldn't be a finable offense any longer if it was outside the box, as long as it was clear that the employee did sign. There's also notes note sections to clarify. And honestly, the best thing to do is if you're unsure about something, to document that I-9 form. So explain the situation if it's out of the ordinary, just so you can show the auditor that you thought about it and that this is what happened, it makes sense, and that's what the note box is for. There's a help button on most fields with clarification, and again, the drop-down menu. There are, however, still challenges to correct completion, because you have to make sure to fill out that form completely, and you have to make sure that you're giving the employee the I-9 instructions to fill it out. Again, the attestation boxes are critical, making sure that the dates are inserted and the form signed. And it's your obligation to make sure that the employee completes and fills out section 1. So that's something like I said, the best thing to do is kind of go over that with them as they do it, to make sure that everything was filled out correctly, all the required information is in there. So section 2 is employer verification. So this is your section as the employer that you have to fill out. So you'll see there's, or that you're going to fill out with the employee. This is where you're going to highlight the documents that the employee has given you to prove both identity and employment authorization. So you're going to see there's list A, B, and C. Now, if you happen to have a list A document, that's where you stop. So usually list A is a combination of several documents that both serve to prove identity and employment information. So a list A document could be a U.S. passport, a permanent resident card, i.e. green card, an employment authorization document, such as what we call an EAD card. It's a card with their picture on it that proves employment. Or if, for example, they're here on an H-2A visa, which is a non-immigrant work visa for agricultural employers, that document, along with their foreign passport, would serve as both as well. So if you happen to have a list A document, stop there. Don't go and do a list B and list C document, because again, that's called over documentation. So even if that employee gives you a list A and then they say, oh, hey, here's my social security card, by the way, which would go under list B or list C, do not accept it. You only accept what is needed to complete the I-9 form. They will be looking at this when they're doing your audit. They're gonna see, if they see anything in list A, but then you have list B and list C, you're gonna be assessed a fine. So you wanna make sure, and I'm a big fan of conducting regular I-9 audits, so you wanna do a self-audit and go through all your I-9 forms, make sure that you have not over-documented any part of that form. The other part of this is some document expiration dates require re-verification. Some do not. So if they're giving you, if they're on an H-2A and they've given you the I-94 document showing their status, there's an end date to that you're going to record on that list A. It's right under expiration date. So you need to have some system in place to be able to track and monitor the expirations and make sure, and I recommend 90 days before, to follow up with that worker and say, hey, your work authorization expires in a few months. You need to give me something else to replace that to show that you've got an extension or another visa. There are some occasions where you may have to complete this section after the start date if the employee completes it early. There are places for 2 documents on list A, but it doesn't mean that 2 documents are required. Sometimes only one's required, sometimes 2 to establish work authorization. So this just goes back to my point about not over-documenting. So section 2, employer verification. So this is the part that you're going to sign and you are going to put the employee's first day of employment. It's very important that this be filled out accurately. So you want to make sure that you do write the date down, the first date of employment, because that's basically going to trigger when the I-9 was required to be submitted. So this will be viewed by immigration when they look at this. You want to make sure that it's signed by a representative of the company with the current date. You want to have all of that filled out correctly on it, but the most important thing is the signature and date on this section. So still some challenges to correct completion. Again, list B virtually has no acceptable identity documents if they don't have a driver's license. And this can be a challenge because the workers may not have a driver's license. So this sometimes is a challenge to find an acceptable document. And if you're enrolled in the E-Verify program, again, you have to remember to get a List B document that has a photo embedded in it, and that's also a requirement. You as the employer have to accept a document if it appears to be genuine and it relates to the individual presenting it. Now, you're not expected to be a document expert or a forensic document expert. You are required to be reasonable. So if something reasonably looks like an official document, it looks like them on the picture, it's unexpired, you have to accept it. Otherwise, that can be considered employment or hiring discrimination. But again, you have to use reasonableness. If something clearly is fake, if it's handwritten, if it just looks wrong, then it probably is wrong. So you're under the obligation to do a little bit further investigation and due diligence to make sure that it's a legitimate document. So re-verification. So re-verification pertains to work authorization only. You never have to re-verify identity. Once identified, always. So all you have to do is if a visa is expiring and that expiration date's noted, then you do have to re-verify. The employee may present a different work authorization document than they originally have. So maybe they started working with you on an H-2A and then for some reason later on got a green card. Well, then they can present to you a permanent resident card. It doesn't have to be the same document. Do not re-verify too early. So even if they get a green card or their status changes, you should not seek out the opportunity to have them update the I-9 unless they voluntarily come to you. That's the only time to do it. So you don't, if they have time left on their current H-2A or other visa, then you wait till they come to you. And a lot of times they will. They're very excited if they get a green card, they want to update their status. So if they come to you directly and say, oh, by the way, I got my green card, here it is, then you can update the I-9 form. You should never re-verify employment authorization on an expired form. So the forms have been changing quite often, the version. So if by the time that you're going to re-verify, the version or edition date of the I-9 form has changed, you should complete a new I-9 form or at least the verification section of the new form. You don't have to fill out the whole thing again. The other thing I want to mention is if you have H-2A workers, if they're going home after the end of the season and then coming back the next season, it's not mandatory that you have them complete a brand new I-9 form. You can keep, if there's an expectation that they're going to return, you can have them just re-verify the initial version of the I-9 that they completed as long as it hasn't expired. You know, sometimes I think that maybe it may be just easier to have them fill out a new I-9 every time. Then you don't have to think about whether the version has changed, but it's not required. You can even just have them fill out that Section 3 re-verification for the next season that they come in. So some general FAQs. Can I complete an I-9 earlier than day one? Yes, you can, but you may not complete it before a hiring decision is made. So you have to go through the hiring dance first. Once you've said, yep, I'm offering you the position, they accept, then you can complete it. As long as there's a non-discriminatory business purpose that you apply consistently. So you can't have one person fill out an I-9 form early and then another one not. You should always be consistent in the I-9 process. May you accept receipts? So you may accept a receipt for an identity document. So if something gets lost and they're replacing it, and a receipt is acceptable for the I-9. You may not accept a receipt for an initial work document. So if they have, you filed an H-2A or there's a receipt notice, but it hasn't been approved, you can't rely on the receipt notice for an initial work document. You may accept a receipt for a lost or stolen or destroyed work document. So if they filed an application to replace it, in that limited instance, a receipt is acceptable. May I accept, and you also may accept a receipt for renewal of certain employment authorization documents. There was a new rule that came into place in November of last year, 2016, that basically gave an automatic 180-day extension on certain visa applications. There are exceptions for TPS, asylees, and refugees. TPS is temporary protected status, so you may not see a whole lot of that. You may accept a receipt for, if they're on a student visa, certain student visas allow employment authorization. There's an extensive discussion of all of the receipt issues in that I-9 Employer Handbook, which again, I suggest that that be downloaded. So here's a common question. Should I keep copies of all the documents that I look at when I complete the I-9 form? The current view, and this has changed honestly over time, and I changed my mind over the years on this. In most cases, yes. Current USCIS guidance says make copies of the I-9 supporting documents that your employee is bringing to you. Previously, there were two schools of thought on this. You know, avoiding documentation of errors versus confirming the correct process, because you're basically saying to the immigration officer, well, yes, they gave me the list A documents, but they also gave me a social security card, and here you have a copy of it in your file. So you don't, and you'd have to turn those documents over in the case of an audit. It's not mandatory that you keep copies of documents, but it may help you if there's a question of whether somebody's lawfully able to work with you or whether the I-9 form was completed properly. If you are enrolled in the E-Verify program, and the employee presents a green card, you do need to make a photocopy of that in that instance. So some of the most common mistakes that I see in the I-9 process, I see where the employer specifies what document the employee is to produce. You know, sometimes this is unavoidable in certain visa contexts, but in most cases, you're not supposed to tell the employee what document to produce. Employer requests or records too many documents. So you've got some eager new hires that want to volunteer every document that they possibly have. Well, it's on you to not record those documents. You can just hand them back, but you need to be careful about over-documenting. The employer fills out the I-9 form too early before a hiring decision can be documented. Employer fills out Part 1 for the employee without an employee signature. You may feel like you're being helpful, or it's easier for you just to fill out Part 1, but it really has to be filled out by the employee, and the employee needs to sign it. The employer sometimes would fail to record expiration dates of work permits to record proper re-verification procedures. So it's important to record the expiration date on the document they give you. So documentation errors alone usually don't give rise to a claim of employment discrimination unless there's some sort of proof that you intended to discriminate. But you're still at risk for unauthorized employment due to documentation errors. And it does not excuse failure to complete the I-9 at all. So again, go back, look at your I-9 forms, make sure that everything's filled out correctly, everything's signed, dotted, and that way you'll be prepared in the case of an audit. So again, some common fact problems here that we see. So Jose completed his I-9 and presented documents which appear to be valid, but I think he's illegal though. What should I do? Well, nothing. You have complied with your obligations under the law. The exception is if you have constructive knowledge from a reliable source that Jose is not work authorized, such as if he asks for visa sponsorship. Well, that's a red flag because he's saying he has a green card and then he's asking you to sponsor him. So there's a red flag there. So how about this one? Maria told me that Jose is illegal and that his green card was a fake. What should I do? Well, you ask yourself, do you have constructive knowledge based on what Maria said? Is she reliable? Does she have reason to know? Do any other facts support her statement? So you've got to look at the specific facts in this situation. Does she have a reason to lie about this? Does she not get along with Jose? Is there a problem there? So it's very fact specific. At the end of the day, if the documents appear to be valid and no other indicators exist, to do nothing, because you don't want to go too far with this and then be engaged of employment discrimination. So a few more problems. I'm hiring independent contractors. Do I have to prepare I-9s for them? No, but the company providing the independent contractor should do so. The company should provide assurances that I-9s have been correctly completed. You really only need to fill out an I-9 form if they're on your payroll as an employee. Can I outsource completion of my I-9? Yes, you may. Employee must be physically present, however, with the examiner of documents. I am employing a worker to perform work outside the U.S. Do I need an I-9? No. I-9 requirements only apply to work that's performed within the U.S. Any work performed outside of the U.S. falls outside of the I-9 purview. So some best practices for basic I-9 completion. The formal ICE rate usually does stem from an initial I-9 audit. Require every new employee to complete Section 1 on the very first day of employment for pay. The employment must provide verification documents by the end of the third workday or they need to be terminated. The employee may present any acceptable documents listed. Do not request a specific document. You should make copies of both sides of all documents to keep with the I-9. If employee is not a U.S. citizen, be sure to note the expiration date of the visa and calendar it to follow up 90 days prior to the expiration. You should keep all I-9s and corresponding documents separate from personnel payroll records. If you do get a visit from Immigration, Customs, and Enforcement, who enforces the I-9 program, they can only ask you for certain documents. But if you have other documents embedded within your I-9s, they may be able to see them. So you want to make sure that you keep them separate. You should train hiring managers or whoever you have designated for I-9 procedures regularly and document training. This will help you later on if there's ever an investigation and they find deficiencies. At least you can show good faith effort to comply. So again, I want to put a plug in for the U.S. Handbook for Employers, excellent resource, examples of many types of documents used in I-9 process, answers to many of the questions that you may have are there. So some common questions that we see for I-9 completion: green cards. You never revalidate any green card information with an expiration date. So even if a green card has an expiration date, and they do, they're valid for 10 years, do not revalid or re-verify this. The card expires, but the status never does. You should not revalidate conditional green cards received through marriage either. So if they marry a U.S. citizen, they get a conditional 2-year green card. That does not need to be re-verified. You must revalidate if presented with a temporary green card stamp in their passport, however. So maintaining I-9 records. So maintaining I-9 copies for the statutory period of time may be done in electronic or hard copy version. You have to keep your I-9 forms at least 3 years from the date of employment or for 1 year after the employee leaves the job, whichever is later. You should, when able, promptly delete I-9s. You don't want old I-9s hanging around, especially if they're filled out incorrectly or there may be problems with them. You're just feeding additional evidence to Immigration, Customs, and Enforcement. Maintain I-9 forms separately from individual personnel records for the reasons we just talked about. You keeping the I-9s in the personnel files compromises privacy of your employees and allows the government inspectors to review items unrelated to the I-9 form. It also saves valuable time in case the Form I-9s are requested for audit. You're only given 3 days notice, so you want to have things organized in a way that's going to allow you to gather the requested documents. It's also easier to conduct internal audits to ensure that you're complying with the I-9 requirements. It's easier to organize for re-verification as well. You should create a tickler system for timely I-9 re-verification. Like I said, 90 days prior to the expiration, you want to make sure you have a reminder system in place to look at those. During the course of your self-audit, if you find things that were done incorrectly or changes need to be made, the general rule is never backdate, never hide a change. You should draw a line right through the incorrect information, write in the correct information, initial and date all changes, and I also like to include a memo stapled to the I-9 form explaining what you did, when you did it, and why. If you need to complete a new I-9 form for some reason, attach the old one to the updated version in the file. As long as there's a consistent policy and there's a reason attached to any changes, that's going to help you later on, and that's going to probably avoid you being assessed a penalty. Immigration knows there's no way to perfectly predict or perfectly complete an I-9 form. There's no way you're going to be 100% compliant. So good faith and showing that you're trying to comply to the best of your ability is the way to approach this. So the I-9 audit, when the government comes knocking on your door, employers' I-9s must be produced within 3 days notice, service of the notice of inspection. So a lot of times this will either be mailed or immigration will come to your door asking, serving you with this notice of inspection. I-9s are usually mailed to the local ICE office. Other documents may be requested as well. Usually those are payroll evidence, payroll lists. Sometimes there's an on-site inspection. When ICE hopes to gather other evidence, proof of presence of undocumented workers, they may want to be on site. Neither consent nor a warrant are required for the I-9 inspection. They don't need a warrant or to show you any documentation. Consent warrant is required for other information gathering, however. You should never consent to additional documentation without a warrant. So what immediate defenses do you have as an employer? Well, ICE agents may make unannounced visits and request I-9s or corresponding information. You don't need to consent to the visit. You should notify your attorney, and you should insist on the 3 days notice. The 3-day notice period is oftentimes, they try to convince you to waive that period, but you should never waive it because you are going to need the full 3 days to do a quick review of your I-9 forms to make sure everything's in place. You should review all your I-9s and correct anything if necessary and sign and date the corrections. You should also try to limit the geographic scope of the agent on site and always accompany them if they are on your premises. The agent does not have the right to roam premises or talk to other employees, without a warrant, that is. So I-9 audits and managing the results. So inspections may lead, I-9 inspections anyway, may lead to different ICE notices. So there could be a compliance letter. That's a great thing to have because it says all is well with the employer's I-9 forms. Notice of suspect documents. An employee may be unauthorized to work. The need for additional evidence to demonstrate work authorization or penalties for continuing to employ. So this will all be indicated in the notice of suspect documents. There could be notice of discrepancies. Here, ICE is unable to determine work authorization for an employee. Employee needs to produce additional documents. There could be a notice of technical or procedural failures. So they'll give you 10 days to correct any identified violations. And this is more for, things that weren't filled out correctly on the form for you to go back and correct that. You can be issued a warning notice. So errors discovered not meriting fines, but they may warn you that you really need to do better at complying in the future. Notice of intent to fine, that's issued for substantive, uncorrected technical, knowingly hiring unlawful workers and continuing to employ violations. So this is for really serious offenses. If they find a pattern in practice that you're hiring illegal workers, then they will assess a fine. This notice, the NIF, does come with charging documents setting forth the violations. At this point, you can negotiate a settlement with ICE or request an appeal hearing within 30 days. No action, ICE will issue a final order with the penalties, or an administrative law judge will be referred for adjudicative process. But a lot of this is going to be the negotiation. You can reach a settlement at this stage as long as you're showing that you've tried to comply and that you're going to comply in the future. So this slide is just sort of like a flow chart of the actual I-9 audit process that we just talked about. Some prevention planning. So in your defense, so if you're issued a notice of intent to fine, you can raise in your defense the existence and utilization of a written compliance policy. So something that shows the procedure from completing your I-9s, your training program for new staff, internal quality assurance, procedures for corrections of errors and for authorized updates, a clear statement of policy on employee failure to deliver documents in a timely fashion, requests for visa services inconsistent with status listed on the I-9, a process for developing a tickler system for re-verification, the procedure that you have for file retention and document retention, as well as purging of I-9s, and your self-audit procedures, internally or by a third party. There are many sources of self-audit checklists, Society for Human Resource Management. There's a lot available online, and even on the USCIS website on their I-9 Central webpage. They give you some procedures and policies on having an internal self-audit system. Self-audit can lead to continuation of original mistakes, so you want to make sure that things are being corrected when they're identified. And then I just want to lay out some useful websites here. Again, USCIS website, where you'll find information on I-9 forms. Within that system, there's an I-9 Central page that has questions and answers on completing the I-9. There's a page on E-Verify, Social Security, Immigration, Customs, and Enforcement, where you can find information on the audit process as part of the I-9 program. And then again, Office of Special Counsel website to kind of get some best practices in your actual recruiting and hiring. Now, honestly, I could spend 2 days on this topic. So there was a lot of information condensed. We didn't talk heavily about the H-2A program, but that may be a topic for another webinar for specific options for agriculture and employers. But that may be something in the future. But if you have any questions, I think we'll be taking those. Otherwise, my contact information is also on this webinar if you have any specific issues.
Well, great, LJ. This is Tom again. Excellent presentation. And we have generated a lot of questions, which is great. And we're going to try to get to as many of those as possible. Just a note for our participants. So the webinar is scheduled to end at noon. LJ has graciously agreed to go beyond that if we haven't gotten to all the questions, because I think a number of these are ones that other audience members are going to be interested in the responses to. So what I'm going to do is we're going to take questions here until the top of the hour, get through as many as we can, kind of take a short break for those who do need to leave the webinar at noon. But then we're going to stay on with LJ to try to get through most of the questions that have come in. So LJ, so start off with one kind of a general one on the I-9 form. The question is that when you mentioned like the expiration time frame for the form, so were you referring, the audience members asking is if you were referring to the form version change or some other aspect of the expiration?
So there's two dates on the I-9 form. The first one is the actual form expiration, which is August 31st, 2019. So you need to look at both dates. The other date is the form version date, which is July 17, 2017. So what happens is sometimes immigration will release a new form before the expiration date of the old form. So you just want to look at more closely the addition date and make sure that you are using the most recent version, which is July 17th, because they may come out with another version, in March of 2018, but the expiration date of the old one is still in effect. So you just want to make sure you're using the right version.
So if that's the case, you do have to use the new version, even if it's within the expiration date of the previous version.
Correct. And when you go, and where to find that information is on the USCIS website under the actual I-9 form. It'll tell you what addition date to use and whether or not they're accepting prior versions. Usually they use a cutoff date saying as of such and such a date, you have to start using the new version. Great.
Okay. And just a comment, we've got a couple questions in for folks who may have joined a little bit late. LJ's handouts are on there's a handout tab on the GoToWebinar panel, and so a PDF of the slides are there for reference. So one question came in when this goes back to kind of the beginning of the presentation where you were talking about the 3-day rule in terms of the things that you need to complete by the 3rd day. But someone mentioned that most of their workers, they only work weekends. So they were wondering if is it the 3rd day after their employment begins or their 3rd day of employment, which may not be until a week later.
So usually what we see is it's employment for pay. So, from when they're added basically to payroll as an employee, it's 3 days from not only the date of hire, but from employment for pay.
Okay, so it's not their 3rd day of employment. It would be 3 days after employment for pay.
Right.
Okay, gotcha. There's a question going back to the beginning where you were talking about the appropriate questions for the interview. One of the audience members asked if that could be avoided by certain things that are in, say, the job order or what's listed in terms of the employer conducts E-Verify, for example. So I'm just wondering what your thoughts is in terms of how that would relate to the interview questions.
Well, sometimes you may know what their status is before you even talk to the employee necessarily. I think the focus should be on what you're physically asking them. I mean, if you have constructive knowledge of what their immigration status is prior to or for documentation that they've already submitted to you, then you're okay to act on that knowledge. It's really only where you know nothing about this person's status, and the only way to find out about it is to ask these questions, or you're going to run into a problem.
Okay. Okay. Someone asked, and this is a little bit of a theme of a number of the questions, LJ, which are, you know, in a sense, if you've done things incorrectly in the past, obviously you've provided great information about what you should be doing going forward. So in this instance, say related to, you know, how do you correct that? In this instance, one of the questions relates to over-documentation.
Yep.
And it's kept on file. What should you do about that?
Well, again, 100% compliance is not possible. But what immigration wants to see is that you are conducting regular self-audits. And why this happens so often is because you can't expect the same person to be handling I-9s for 15 years. In all industries, there's always turnover in the human resources function or in the person responsible for completing the I-9. And they may not have done it correctly in the past. So it's the whole thing of, you know, inheriting the sins of your predecessor and the
Right.
errors of them. So I think whenever somebody new starts or somebody new is tasked with I-9 completion, that's when the audit should take place, the self-audit. Go through them, and then any errors that you found should be corrected at that time. So if it's been over documentation, honestly, what I would do is I cross off list B and list C. If it was not needed, or if anything was included on there, just cross it out, and then initial and date it, and then attach to that I-9 form a memo saying on such and such a date, I took over I-9 management and compliance. I conducted a self-audit. During the self-audit, I noticed that there was over-documentation or that some forms were incompleted incorrectly. We immediately took action to correct that. And going forward, we have a training program or a policy in place in how we're going to prevent this from happening. As long as you just come clean, be honest about it, it's going to be fine.
Okay. And kind of related to that, so if in an over-documentation case, you go in, you correct the form, put in the memo. If copies of the over-documented documents are with you in the file, should the ones that aren't needed be be destroyed or shredded?
Yes. I would recommend shredding them, and then you're going to say in that memo of explanation that all documents that were incorrectly accepted have been destroyed.
Okay, great. So here's one that's kind of specific to H-2A. So if they come in with an H-2A visa, they have a passport. Would they put that in List A and then not put down a Social Security number after they receive one?
Right. The Social Security number isn't required. So we look at there's a difference between what's required under the immigration law to have someone work in the U.S. versus what may be required for payroll purposes. For immigration doesn't necessarily care about the Social Security number because it's not required for somebody to work. So in the H-2A context, it would be List A. You would accept their I-94 arrival departure record, which is issued to them when they come in. It'll show H-2A and then the expiration date. And then you would use a copy of their foreign passport in most cases. And that's all you need for H-2A. You can ignore List B and C. Okay.
When you're looking at the employer required sections, in terms of Section 3 for rehires, So for, say, an employee who comes year after year for a seasonal job, is that one where you would need to go to Section 3 in terms of it being a rehire?
Yes, so that would, as long as there's an anticipation of continued employment, so they're the worker that comes in H-2A every season, you could just take out the I-9 form from the prior season they were here and have them fill out Section 3 only for when the next time they come in. Obviously, you only have so many Section 3s on one form, so you're going to have to, after for the third entry on H-2A, you have to have them fill out the Section 3 of a different I-9 form. But as long as the version hasn't changed and it's still valid, you can re-verify on that same form.
Great. Hey, LJ, so as we're getting towards the top of the hour, could you advance your slide? I think you have a slide with your contact information, and then that'll be shown to the participants who may want to get in touch.
Yep, sure. Yep. So, my email address is there and my phone number. So that should appear on the slide now. And then people can feel free, if you have specific questions that you're not comfortable asking in this forum, then I'm happy to answer anything later.
Okay. So I'm going to keep going with some questions here. One of the other, again, themes among some of the questions we've gotten in relates to re-verifying things. So you may have covered this. Should employers re-verify do they need to re-verify a permanent resident card?
They do not. So, and this is confusing because there is an expiration date on a green card. It's valid for 10 years, but the difference with permanent resident status is that the status never expires, only the card does. And the reason is because immigration wants everyone to have a card with a current picture on it. So they don't want anything more than 10 years old. So if they give you a permanent resident card, whether it's valid for 2 years or 10 years, you never re-verify that.
Okay. So here's a kind of a specific question in terms of the documentation requirements, in terms of list A, that specific instance, but I think might be good illustration. So if someone brings in one form of ID, like a driver's license, and say they're going to bring in a social security card or a birth certificate, but then they end up bringing in a passport instead, but they've already, say, written down the driver's license in B, should they, what should they do in that instance? Should they,
if
they avoid over documentation?
Yep. Yeah, so what I would do is if the worker comes in after the fact and for whatever reason wants to replace it with a different document, even after the I-9 has been completed, I would go ahead and accept that change. But what I would do is just have, initial and date, cross off the prior document that they don't want to use anymore, and have them, and then just fill in the new document, initial, date it, and then again, attach a memo to the I-9 explaining on such and such a date, employee came to us requesting that we replace a previously submitted document with this document, whatever it is, just so they understand what happened, the context of this change, and in case there are any questions.
Okay. So we are at the top of the hour now, so I am just going to take a pause for those for those participants who do need to leave the webinar. I would note that this is being recorded, so the full version, obviously the Q&A is a great way to illustrate some of the specific examples of what LJ has covered. But as I said, hopefully we can go on for about another 10 or 15 minutes, and that way we'll get to everyone's questions. This has been a great discussion. So kind of referring back to the question we just covered, LJ, in terms of the different forms of ID, this is an employer, it looks like a lot of seasonal college students, for example. What about scans or photocopies? In some cases, they're saying student workers, their folks don't want to let them have the original documents.
Yeah, so this often comes up, and this is a difficult one because the law requires that the employee present an original document. They're not allowed to accept photocopies or scanned copies, and this is a problem in many different industries because, especially where we have a company that has a central administrative location, but the worker may be working in another state. It would be much easier if they would allow somebody to scan and email documents, but there has to be a face-to-face meeting and it has to be an original document. Whether or not that would be strictly enforced? Maybe not, depending on the situation. But normally what we see is, you know, the fact that the employee is working in a different location, and that's why they can't produce an original. But in this case, it's that the worker doesn't necessarily have the original. But for employment purposes, immigration would expect that they'd be able to get the original document for this limited purpose to present to the employer. So there's probably not a whole lot to do to get around that requirement.
Okay. Here's a real technical one in terms of the compliance aspect. On the form with the 2-digit versus 4-digit format, I'm not sure I understand the question, but in terms of adhering to that?
On the actual I-9 form?
Yeah, I believe so.
I'm not sure I understand that question.
Let's move on then. So in terms of and I think kind of the first question about which version of the I-9 we're talking about, you know, if let's say you did in a sense by mistake use an old or out-of-date form, is that something you should note in kind of a self-audit, or is that something that, you know, you should go ahead and have them do, you know, fill out a new form?
I would probably have them fill out a new form on the current version of the form, and then write an explanation. It's always the most conservative approach for all of this is to complete a new I-9 form, but just keep it with the old one to note any changes and explain what happened. The biggest thing is an explanation, but I would just have them go ahead and complete the new one. That's probably something that's more minor, and they probably won't be penalized for that. But it just goes to show that they're really trying to do whatever they can to comply.
Okay. In terms of recommendations on how to approach an employee for re-verification.
You can do it pretty much any way that you want. You can give them a call them to the office, send them an email, you know, and just say, a record show that your visa authorization is expiring in 90 days, and we need to take steps to update your I-9 form. So please bring us information that, and again, you don't have to re-verify identity, but you need to ask for some documentation that shows that they're legally able to work in the U.S. And then you leave it up to them to choose what that document would be.
Okay. In terms of if ICE is conducting an audit, and now are they permitted to take the original I-9s if they request them?
Yes, they can take the originals. No, I haven't seen them do that. So normally the reason for the 3 days notice is that you can assemble everything. In most occasions that I've seen, you just photocopy them and you mail them to the immigration office that they specify in the notice. I haven't seen them requiring the actual originals, but that doesn't mean that they cannot. So I would just, you know, most of the time they're going to give you time to make the photocopies of everything, and then you just ship them out, and then they work off the copies.
Okay. Now you talked a little bit about in terms of how to keep the documentations in terms of keeping the I-9 separate. So, for example, so the copies of the IDs that are the backup for, you know, what was used for the verification, so that should be kept separate from the I-9s in a separate personnel file?
No, that anything that if your policy is to make copies of documents presented in I-9 completion, they need to stay with the I-9. So okay. That documentation would be kept attached to the I-9 form. If your policy has traditionally been to not make photocopies, then you won't have those with the document. The only documents you want to keep separate, or you just don't want to have payroll documents mixed in, or other documents for the employee that aren't related to I-9 completion.
Okay. Okay. And included in that, like the driver's license was used, that should be, I mean, that's okay for one to keep a copy of if that's your policy?
Yep. If that document was specifically listed on the I-9, then that would go with the I-9. So I would just limit it to any document referenced on the I-9 form that you're going to keep with it.
In terms of document retention, there's clarification here. So I-9s of employees that are still currently working and have been here for 3 years, I mean, those should be retained, correct?
Yeah, it's confusing. But so the general rule is if an employee is still there, you keep their I-9. It's only the consideration is only after they leave, I guess.
Okay. Okay. And then in terms of an audit, and when you talked about the notices that an employer might receive in terms of notices of violations, et cetera, at what point in an audit, should you recommend them seeking legal counsel?
Well, they can seek legal counsel at any time. It really depends on whether the employer is comfortable with the I-9 requirements. So if they've been doing it for years and they regularly engage in training and are comfortable with it, then that's something they may be able to handle on their own. Or maybe they can do an initial submission, and then if immigration comes back and they have additional questions at that point, they may want to get someone involved to help. But it really does depend on the level of compliance that they have historically. If they know that they have workers that are out of status or are questionable, then they may want to seek help from the start.
Okay. And this gets back to the kind of the documentation that goes with the I-9. So you kind of went over for what items would they need a warrant. So in a sense, they can only look at the I-9 file without a warrant, but that's where the supporting copies of documents would be kept, correct?
Right.
Because I think would they need a warrant to go to, say, a separate file, let's say a personnel file?
It depends on what the documents are. So with the notice of inspection, we often see them asking for a list of employees, sometimes even business documentation showing the incorporation of the company, and they can ask for those without a warrant. And I don't know that it's been litigated, but there's a question of what is really allowed to be asked from an employer in connection with an I-9 audit. It's very easy for them to get a warrant. So if they're going to come back and do an actual raid, then they need a warrant to inspect other barns or property or locations on the farm. So that would definitely require a warrant, or even to talk to workers. They're not really supposed to engage in conversation, and so you can do some things to minimize their interaction, especially accompanying them. I've had clients that walk around with a video camera, while accompanying the ICE officer, just to protect themselves. They will, in the context where they do have a formal warrant, still there are things that can be done to keep a very detailed list of anything that they take, any documents they take. But I haven't seen the I-9 audit go to that extreme, but they do generally require payroll, because what they need to do is they need to look at the payroll documents and compare it to the I-9s on file to make sure that every employee on the payroll has the I-9. So that's pretty standard practice. But I don't see them asking for a lot of other documents that are unrelated to payroll.
Okay, understood. Okay, great. So I think we'll stay on for about another 5 minutes here for questions we're not going to be able to get to. We will follow up with individuals in our GoToWebinar. We do have the names and addresses of the folks who have submitted questions, and so we will follow up on all of those. But I think we got time to get to a few more. So I know we're not really covering H-2A today, although I think a few of the instances do come up in that context. But kind of a general question coming up about dairy farmers or folks with year-round operations using H-2A.
Yep. In connection with I-9s?
Well, I think it's more of a general question about using H-2A generally.
Okay. So yeah, the H-2A program is seasonal. So it has to be tied to a specific season of the year. And unlike other visas, the definition of seasonality in the H-2A context has to do with a certain position. So we generally see farm workers. So farm workers on the H-2A would come in, let's say March 1st, and they'd stay until the winter months when after harvest is done. So normally we see March 1st to November 30th. Well, that's a specific need for the farm worker / crop position. But employers may need workers in the winter for a different position. So what I see a lot is, there's a separate seasonal need tied to the winter for a winter grounds maintenance worker, let's say, or an agricultural equipment operator. Those are different SOC codes, standard occupational classifications in the Department of Labor system. So Department of Labor and USCIS, and we've had to litigate this issue actually in front of an administrative law judge because we were getting problems with Department of Labor and USCIS about this. But it was clarified in court proceedings that the government is supposed to look at the need of the employer for the particular position. So what we've been able to do is do 2 separate positions a year. So employers may have a need for winter grounds maintenance, for path clearing, for snow removal, de-icing, equipment maintenance, milking parlor equipment maintenance in the winter months. So they're able to get a separate position, which would run from, maybe November 30th to March or April. That covers the winter need. So you're allowed to basically transfer workers between both of these programs per year. So in a sense, a worker could be in the U.S. in H-2A for up to 3 years without setting foot outside the U.S. between these 2 programs. After they've been here for 90 days, after they've been here for 3 years consecutively, then they need to leave the U.S. and stay out for 90 days. That resets the 3-year clock, and then they can come back and rotate between these 2 positions. So it's important to really specify in the applications, though, that these are truly distinct positions with separate seasonal needs. Now, we do get, kickbacks from Department of Labor and USCIS periodically saying, what's up with this? It looks like the employer has a year-round need, and that's where we have to go and educate them, cite the regulations to show them that it's based on the position in terms of the employer's specific need. And in most cases, we've had no problem doing that. We've had case law to support it.
Okay, very good, very good. So last question. So what about long-term employees who haven't had a status change, but when they're, but obviously when their original I-9 got done, it was on a previous form. I mean, when new forms come out, do those need to be revisited, or is the form that was valid?
As long as the form was valid and with the correct version at the time it was completed, you don't have to go back and put it on, and do a different form, or as long as you only have to think about that is in the context of reverification or when they're coming in on a new visa. So you're going to look at the time that the employment's starting, what's the correct version of the form to use. And as long as you're doing that, then you don't have to go back in time.
Okay, great. Well, LJ, just want to say thank you for your time today. A great presentation, and thanks, everyone.